Well, Gabby's parents filed their response to Brian's parents' request to dismiss the lawsuit, the Petito versus Laundrie lawsuit for emotional distress. And why? Because the Constitution doesn't apply. That's what they're arguing. All right, so I'm going to walk you through the motion to dismiss, their reply to Brian's parents' request to have the court dismiss. I'm going to walk you through what Gabby's parents' response is as to why their lawsuit should not be dismissed and why the Constitution doesn't apply. All right. Hi there, I'm Michele Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes case. And by the way, you might want to take a look at the prior video I did on dismissing the Petito versus Laundrie case, which will explain to you what Brian's parents allege, what their defenses are. Basically, the First Amendment, they had right not to speak. The Fifth Amendment, they also had a right not to incriminate themselves by speaking, allegedly, right? The right to remain silent. Sixth Amendment, the right to counsel, which according to this motion to dismiss, this reply filed by Gabby's parents, that doesn't apply. So let's take a look at what they have to say. And this video is for educational and informational purposes only. I'm not a Florida lawyer. I'm a California lawyer. This video is simply my opinion, and I want to know what's your opinion. What's your opinion on this? What's your analysis? Please leave a comment. Please do support my work. Please subscribe by supporting my work. And please hit the like button, share these videos, and do leave a comment. All right, so let's take a look. I'll walk you through this motion, this reply to Brian's parents' request for the court to dismiss the Petitos lawsuit. All right, so here it is. It was filed earlier today. So, filed April 11th, 10:47 a.m. in Circuit Court, which again is the trial court in Florida. It's Joseph Petito and Nichole Schmidt, which are Gabby's parents, which are the plaintiffs. They're the ones bringing the lawsuit for intentional infliction of emotional distress against Brian's parents because they withheld information as to where Gabby was, what happened to Gabby, etc. So the defendants are Brian's parents, Christopher and Roberta Laundrie. Says plaintiff's response to defendant's motion to dismiss. So this is the plaintiff's, Gabby's parents' response to Brian's parents' motion to dismiss the lawsuit. So you can go ahead and read this. They filed the lawsuit was filed March 10, 2022. The complaint stated a claim based on intentional infliction of emotional distress. The plaintiffs are the parents of Gabby Petito, who's deceased. Tragic. I mean, this is a tragedy. Tragedy. Both families lost their children. Gabby Petito was brutally murdered by defendant's son, Brian Laundrie, also deceased by apparent suicide. The plaintiff's complaint alleges that the defendants, Brian's parents, were aware that Gabby was deceased and were aware of her location of her lifeless body, and despite pleas from the plaintiffs, Gabby's parents, the defendants refused to provide any information to Gabby's parents regarding whether or not Gabrielle Petito was still alive, and if she was not, where her body was located. This is very, very sad and very tragic. So the defendants, Brian's parent, filed a motion to dismiss on March 30th, and again, go ahead and take a look at the video I did. I walked you right through what their reply was and why their reasons for the motion to dismiss. And that's in the video if you go look at dismissing the Petito versus Laundrie lawsuit, the U.S. Constitution. In this case, it's the Constitution doesn't apply, apparently. All right? So we're going to see here. So they give the case law. The court has to limit it. Remember when I talked about in the prior video, to the four corners of the complaint. That's all the court looks at in a motion to dismiss. Did you allege all the elements of the causes of action of intentional infliction of emotional stress. Are there enough facts there to support those elements? That's basically what the court is looking at. A complaint should not be dismissed for failure to state a cause of action unless it appears beyond doubt that the plaintiff would prove no set of facts that would entitle him to relief. So in other words, if you look at that prior video, talk about where they say even there isn't anything else that the plaintiffs could allege to support. Well, they're saying they don't need to because they have enough facts. So the function of a motion to dismiss is a question of law, the sufficiency of the facts alleged to state a cause of action. So in other words, the judge makes a determination in this motion to dismiss whether or not to grant it or deny it, whether or not there was a sufficient amount of facts alleged in those four corners of that lawsuit, of that complaint that Gabby's parents filed against Brian's parents to support a cause of action for intentional infliction of emotional distress for withholding all that information, allegedly. Okay, so you can go ahead and read this. And they talk about consideration of potential affirmative defenses, meaning the constitutional defenses, the First Amendment, the Fifth Amendment, the Sixth Amendment, right? Free speech and also refrain from speaking, First Amendment. That's an affirmative defense, is what they're claiming here. Fifth Amendment, the right to remain silent, not to incriminate yourself, also an affirmative defense. Sixth Amendment, right to counsel, also an affirmative defense. I assume that's what they're stating here, right? So, and they had alleged in their motion to dismiss, Brian's parents alleged that the pleading, the four corners of that complaint was insufficient, was deficient because it did not mention the phrase intentional infliction of emotional distress. Well, Gabby's parents say here that they don't need to use the words as long as they plead, they state, and have facts to support each one of those elements, and I'll get to that. And there was also, in that video and in the motion to dismiss by Brian's parents, they had said they weren't sure whether Gabby's parents were saying it was an intentional infliction of emotional stress or it was tortious interference with the dead body. And Gabby's parents are saying here, no, we never suggested that. It's intentional. It is intentional infliction. It has nothing to do with tortious interference with the dead body. You say, and it says right here in paragraph 8, nowhere in the complaint is there any suggestion that the claim is based upon torturous interference with the dead body. Simply because the words intentional infliction of emotional distress does not appear within the body of the complaint does not make the complaint defective. Now again, the judge is going to make the decision, right? The judge is going to review the motion to dismiss by Brian's parents, what they said in their motion. The judge is also going to look at what Gabby's parents are saying in this motion. It's probably going to have a hearing to let both sides, both counsel, both Gabby's parents, Brian's parents, argue, present further arguments as to support why the lawsuit should be thrown out. In other words, the motion to dismiss should be granted or why it should not be granted, okay? And this is Gabby's parents are stating the reasons why the motion to dismiss should not be granted. They're saying we don't have to say intentional infliction. As long as we put the facts in those four corners that support each one of the elements of intentional infliction, we're good. All right? So they also respond to failing to meet the factual pleading requirements. And here are the four elements that they must allege, which they say that they have alleged in those four corners. Deliberate reckless infliction of mental suffering, outrageous conduct. Conduct that was caused severe emotional distress, and the distress was severe. Those are the four elements they have to prove in their lawsuit. In order, they're going to have to prove it to a jury, assuming they survive a motion to dismiss. If this case goes forward, those are the four elements that they have to prove to a jury in order to find Brian's parents liable for intentional infliction of emotional distress. And then if they do, jury does find them liable, then what amount of damages would they award Gabby's parents? That's something the jury would also decide. But this is the pre-trial phase. This is the motion where parties file motions like this to dismiss, to get the case thrown out so it doesn't go any further. Okay? So they talk about the first requirement is deliberate and reckless infliction of mental suffering. And here are the facts that they pled in their complaint, and they're just restating it here, that the cause of death was blunt force injuries to the head and neck by manual strangulation. It is believed it happened on or about August 27, 2021. Brian Laundrie murdered Gabrielle Petito. I mean, this is very sad, very tragic. And it is believed that Brian's parents were advised by Brian that he had murdered Gabby. There was no contact between the parents, and then on September 19th, tragically, they found Gabby's remains. And the parents, understandably, were extremely distraught and were attempting to locate where Gabby was prior to that time. While Gabby's parents were suffering, the Laundrie family went on vacation. This is all in their complaint. They're just restating it here. In order to avoid contact with Nichole Schmidt, Roberta Laundrie blocked Nichole Schmidt on her cell phone and blocked her on Facebook. You go ahead and read that. And then with full knowledge that Gabby had been murdered by their son, they issued this statement through their lawyer. You can go ahead and read this. And then Gabby's parents issued a statement through their lawyer, writing a letter to Brian's parents. We're writing to ask you to help us find our beautiful daughter. We understand that you're going through a difficult time and your instinct is to protect your son is strong. Okay? Yes, parents, we protect our children, right? We ask that you put yourselves in our shoes. We haven't been able to sleep or eat, and our lives are falling apart. It's very sad. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you and your family have any decency left, please tell us where Gabby is located. Tell us if we are even looking in the right place. All we want is Gabby to come home. Please help us make that happen. It's very sad. And despite the fact they implored Brian's parents to tell them where her remains were located, whether she was alive or not, Brian's parents refused to respond to them and to law enforcement. Then they talk about deliberate and reckless infliction, that they knew that Brian had murdered Gabby. They knew where the body was. They deliberately took efforts to block. This paragraph 12 are all the acts that they're alleging, all the facts that they're alleging that support possibly that Brian's parents were helping Brian, were assisting him. They deliberately took efforts to block the ability to contact them. They went on vacation with their son. They issued a statement through their lawyer, and all the time knowing that their son had murdered Gabby Petito and hidden her body. It's really sad. You can go ahead and read this. And then they talk about the conduct being outrageous, so extreme in degree as to go beyond all possible bounds of decency. And that decision, they're saying, Gabby's parents saying, is to be made by the judge because it's a question of law, not a question of fact. In other words, it's not whether you and I think that Brian's parents withholding the information was so outrageous to be beyond all possible bounds of decency, not to help Gabby's parents find Gabby. The question is what the judge would say. It says the burden falls on the judiciary. It's a matter of law, not a question of fact. So rather, an evaluation of the claimed misconduct must be taken as objectively as possible. Objectively. Was it atrocious, utterly intolerable? And that falls on the judge to decide. That's what they're saying, okay? What the judge decides, we're going to find that out. We'll find that out when they have the hearing. And I don't know what the date of the hearing is yet. I don't think it's set yet, but we'll find out. Okay, so at this stage of the proceeding, Gabby's parents are saying it's not the burden on the plaintiff to prove the conduct was outrageous. Rather, the question is whether there are sufficient facts pled, meaning everything that they have stated in their complaint, as well as what I just read to you, whether that's enough, that those allegations must be accepted as true, if that's enough to survive a motion to dismiss. Did they plead sufficient facts? And that's a call for the judge to make. And here's what they say. Can anyone truly suggest that it is not atrocious and utterly intolerable in a civilized community to refuse to tell grieving parents where their child's remains are located? Can anyone truly suggest? It's a pretty sad statement to make, and again, it's a question of law. This question, respectfully, I say this respectfully, may be more of a question regarding facts, okay? So it's up to the judge to make this call. But refusing to tell grieving parents, that's really hard. Okay, and then they talk about another element is this unequal position between the parties and the heightened degree of outrageousness, because one party, Brian's parents, had information in a higher position, so to speak, right? They had more information than Gabby's parents did, so therefore it makes it more outrageous. I think this is what they're implying here. And defendants clearly had the power to affect the interests of the plaintiffs, and they knew that the plaintiffs Gabby's parents were desperately searching for her daughter. Defendants knew where she was, and they refused to provide the information. So then they also say here that we did plead enough facts to support that their conduct caused emotional distress. They knew that they could alleviate, at least in part, the suffering. And again, this is repeating what's in the lawsuit, what's in the complaint filed by Gabby's parents initially. And they had great indifference to the rights of Gabby's parents. And here's what they say. Because they didn't provide the information to the plaintiffs, it caused the plaintiffs continuation of their distress and likely increased it. And that the defendant's suggestion that the conduct of the Laundries had to be a sole and proximate cause is without merit. In other words, they don't have to show that the Laundries' failure to provide the information was the cause of the distress. If it was at least part of the cause, doesn't have to be the sole cause, but if it's part of the cause, that's enough. That's what they're arguing. That's going to be interesting. It's going to be interesting how the judge decides on this causation element. And then paragraph 18, defendants incredulously suggest that the plaintiff's complaint does not allege, let alone factually support, that the emotional distress was severe. In other words, what they said in their complaint, all those facts that they put in those paragraphs, again, go look at the video I did on dismissing the lawsuit, and also the video I did of walking you through the lawsuit, where they talk about what are the facts to support severe emotional distress. And they say here it's ironic. It's an ironic suggestion given that the defendants themselves experienced the same emotional distress when their son was missing. In other words, are the Laundries going to suggest that their suffering wasn't severe? Because that's exactly what Gabby's parents was going through. It's a very interesting argument. Okay, then they cite to a bunch of cases to support their position. You can go ahead and read that. And then they talk about as a direct and proximate result of the willfulness and the maliciousness on behalf of the Laundries, the Petitos, Gabby's parents, suffered pain and suffering, mental anguish, inconvenience, loss of capacity, etc. And then paragraph 22, for the defendants to suggest that Gabby's parents' grief and mental suffering was not severe is disingenuous and frankly disgusting. This case is not about fright, shame, worry, or humiliation. Is there any greater horror for a parent than to lose contact with the child with whom they had daily contact, while the party with whom the child was traveling returned home safe, and that the child and the family refused to provide any information regarding the plaintiff's missing child? Where was Gabby? And they say that they have pled, sufficient facts. The allegations in the complaint plainly and clearly describe severe distress experienced by the plaintiffs. Okay, here's where the Constitution comes in. The defendants have said in their response to, or their request to dismiss this lawsuit, is the Constitution. They cite to the Constitution repeatedly. First Amendment, Fifth Amendment, Sixth Amendment, right? So they're saying, yes, you do have a privilege, but not under these circumstances. And why is that? You have the right to remain silent, but not under these circumstances. And here's where they say, we begin with the proposition that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. In other words, they're saying that because there was no state action, it was a private party asking for the information. It was Gabby's parents asking another set of parents. The government wasn't involved. It wasn't a state action. It wasn't the police. Yes, I mean, the police were involved as far as investigating, but it was simply Gabby's parents reaching out and asking them to speak, asking them to give information. There was no state, there was no government involved in that. That's what they're arguing. It's an interesting argument. Okay, so they're saying basically the Constitution doesn't apply. They don't have the right to say we can remain silent when the government isn't involved. Okay, and you can go ahead and read this. These are cases that are supporting their proposition. Again, the defendant's reliance on the First Amendment, that they had no obligation to disclose whether Gabby was alive or where the body was located is misplaced. They're saying their argument is misplaced. The Constitution doesn't apply here. No state action. Again, you can read these. Here, the government forcing a private party. There was no government forcing a private party. There was parents asking other parents for information. Again, it's an interesting argument. In this matter, paragraph 29 sums it up. In this matter, there is no state action at issue, and the defendant's right to First Amendment rights are not implicated because there's no state action. While they may choose to say nothing, they have no constitutional right under the circumstances herein to remain silent. Very interesting. Defendants also suggest that they have a Fifth Amendment constitutional right. Remember, the right to remain silent, not to, there was a criminal investigation going on. They say that the defendant's right to suggest that they had a Fifth Amendment constitutional right not to speak in the face of a criminal investigation. Then the defendants go on to state that there was unquestionably a law enforcement investigation regarding the disappearance of Miss Petito, but the defendants' arguments are premised on alleged facts that are not within the lawsuit. In other words, they're pulling in facts, information that are not what Gabby's parents are arguing. So therefore, it doesn't apply. And they're also saying that the Sixth Amendment right to counsel doesn't apply. So quite interesting. This is a quite interesting response here. And then here's one of the last arguments is that the defendants arguing correctly that for conduct to be actionable as intentional infliction, the conduct must be directed at the plaintiff and in their presence. Well, Gabby's parents are saying that's not true either. Because where such conduct is, it requires where conduct is directed to a third person. This is not conduct directed to a third person. This is conduct directed to a member of her family, right? To her parents. So plaintiffs have alleged that the conduct of defendants was directed specifically at Gabby's parents. And they weren't suggesting, Gabby's parents were not suggesting that the conduct, the infliction of emotional distress was directed at someone else. No, it was directed directly at them. Therefore, they have met the requirement. And this is where they say, plaintiffs respectfully, Gabby's parents respectfully request that this honorable court enter an order granting in part the motion to dismiss. So they're saying, Gabby's parents are saying, yeah, we failed to assert the separate claims for Roberta Laundrie and for Chris Laundrie. Therefore, we're asking the court to give us 20 days to file an amended complaint. And that happens all the time. It's up to the judge whether the judge gives them the time to amend the complaint, to separate those causes of action. But they're also saying, and to deny the remainder of the motion to dismiss. In other words, let this lawsuit proceed. Don't dismiss it, because they're arguing we have met all the requirements. It's sufficiently pled. There's enough facts and information within those four corners that this lawsuit should proceed. So we'll see. We'll see what happens at the hearing. I'm sure the judge will have a hearing, and there may be I'm also pretty sure that Brian's parents are probably going to respond to Gabby's parents' response. They'll probably submit a reply, or they'll argue it at the hearing. We'll see what happens. So, it's a question of whether the judge is the one who's going to make the call. There's no witnesses. There's not going to be a hearing where there's witnesses and there's testimony. The judge makes the decision based on the motion to dismiss filed by Brian's parents, based on the response filed that I just went over with you by Gabby's parents, and possibly a reply by Brian's parents, and whatever statements are made at the hearing by counsel. But it's not a trial, it's just a hearing, okay? And the judge will make a determination as to whether or not they grant the motion to dismiss. If the motion to dismiss is granted, the lawsuit is out. That's it. They're done. They can't proceed with the cause of action. If the motion to dismiss is granted with leave to amend, to separate those causes of action, then the motion could be heard again later if they decide to file an additional motion. I don't think that'll happen, but the motion to dismiss, maybe they can amend the complaint, or maybe the judge decides, no, you can't amend the complaint. And the judge could decide, whether or not to dismiss the lawsuit or not. So we'll see what happens. I'll keep you posted. So please do leave a comment. I want to know what you think. That's why I created this channel, not only for me to provide you with more legal analysis, but to get your analysis. What's your take? Do you think those are valid arguments? Do you think the Constitution doesn't apply? How do you think the judge is going to rule? What's your opinion? What's your analysis? So please leave a comment, hit the like button, hit the notification bell, and please do support my work. So please subscribe to this channel. Thank you very much for watching.